Right now, the Supreme Court is deciding the future of women's sports. Two cases: Idaho and West Virginia, laws that ban biological males from female sports. The justices will rule this year, and no matter which way they rule, they're going to get it wrong. Not because the justices are stupid, not because they're corrupt, because the entire legal framework they're working with is built on lies. If they rule for the states upholding the bans, they'll do it by saying Title IX allows reasonable sex separation. But Title IX doesn't say that anywhere. If they rule against the states striking down the bans, they'll do it by saying sex includes gender identity. But no law ever defines sex that way. Not Title IX, not Title VII, not any statute passed by Congress. Ever. Both sides are arguing over what words mean. Words that were never defined in the first place. Words that courts have been redefining for 50 years based on nothing. No statutory text, no congressional intent, just inference stacked on inference. The Supreme Court is about to issue a ruling that will affect millions of women and girls. And the entire foundation of that ruling, no matter which way it goes, is a house of cards. Let me show you how we got here, and why the only real solution isn't a court ruling at all. January 13th, 2026. The Supreme Court heard arguments in two cases. Little versus Hecox, Idaho's law banning males from female sports. West Virginia versus B.P.J, West Virginia's version of the same law. Here's what the justices are wrestling with. Does Title IX, the 1972 law prohibiting sex discrimination in education, allow states to separate sports by biological sex? Or does excluding transgender athletes from teams matching their gender identity violate Title IX? Listen to what the justices said during oral arguments. Chief Justice Roberts seems skeptical that Bostock, the 2020 case about employment, applies to sports at all. Justice Gorsuch said, Javits changed Title IX. It said, sports are different. He even questioned whether Title IX passes constitutional muster because in 1972, sex meant biological sex, and states accepted federal funding based on that understanding. The court seems ready to rule for the states, to uphold the bans, and most conservatives will celebrate. But here's what nobody's talking about. Even if the court rules the right way, they'll be doing it for the wrong reasons based on legal fictions that don't exist in any statute. And those fictions will come back to haunt us. Let's look at what Title IX actually says. 37 words. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. That's it. That's the whole thing. Now let me show you what's not in those 37 words. Woman, not there. Female, not there. Male, not there. Gender, not there. Gender identity, not there. Sports, not there. Athletics, not there. Definition of sex, not there. Title IX doesn't mention women, doesn't mention sports, doesn't define sex. So where do women's sports come from? Everyone, including Justice Gorsuch, points to the Javits Amendment. Here's what it actually says. Regulations must include reasonable provisions considering the nature of particular sports. That's it. Read it again. Reasonable provisions considering the nature of particular sports. Does that say separate teams by sex? No. Does that say women's sports are allowed? No. It's talking about funding. Football costs more than volleyball. Equipment differs. Facility needs differ. The Javits Amendment was about money, not sex segregation. So where does sex-segregated sports actually come from? Regulations, written by unelected bureaucrats at the Department of Health, Education, and Welfare. Not a law passed by Congress. Not text in any statute. Regulations that can be changed by any administration. Without a vote, women's sports exist because of a regulation. Not Title IX. Not the Javits Amendment. A regulation that any president can rewrite. And the Supreme Court is about to issue a ruling based on this house of cards. But it gets worse. Even if the regulation holds, even if the court rules for the states, they still have to answer a question that has no legal answer. What does sex mean? Title IX doesn't define it. Title VII doesn't define it. The Civil Rights Act of 1964 doesn't define it. No federal statute has ever defined the word sex. For decades, everyone assumed it meant biological sex, male and female. But assumptions aren't law. And when you leave a word undefined, you hand courts a blank check to redefine it however they want, which is exactly what happened. In 2020, the Supreme Court ruled that firing someone for being gay or transgender is sex discrimination, under Title VII. Their logic: you can't know someone is gay without knowing their sex. Therefore, sex is a factor. Therefore, it's sex discrimination. By that logic, everything is sex discrimination. Fire a father? You knew he was male. Sex discrimination. Fire someone with a beard? Only males have beards. Sex discrimination. The but-for test eats itself. It makes sex mean everything, which means it means nothing. And now courts are applying Bostock to Title IX. If sex includes sexual orientation and gender identity in employment law, why not in education law? Why not in sports? The conservatives on the Supreme Court are trying to limit Bostock, trying to say sports are different, but they're building on sand because they're still working within a framework where sex was never defined. Women's sports rest on a regulation, not a statute. The Javits Amendment doesn't say what everyone thinks it says. 50 years of case law is based on inference, not text. No matter how they rule, they're reinforcing a broken system. So, how did we get to a place where the word sex can mean anything a court wants? One man. But before I tell you about him, let me show you what the words used to mean. In 1755, the word sex had one meaning. Two options: male, female, end of definition. In 1755, the word gender meant something completely different. Gender wasn't about people. It was about grammar. And it stayed this way for 200 years. So how did we get here? How did gender become something separate from sex? How did we end up with laws that can't define woman? How did we get to a place where protecting female sports is called discrimination? One man, John Money. In the 1950s, Money took a grammatical term and repurposed it to mean the social role associated with sex, separating it from biology. He argued gender was learned, not innate. Sexologist John Money coined the term gender role and was the first to use it in print in a scientific trade journal. Before his work, it was uncommon to use the word gender to refer to anything but grammatical categories. A psychologist from New Zealand who sexually abused twin boys for a decade, photographed them in sexual positions, lied about his research for 30 years, and watched both of them die by suicide. And his ideas became the foundation of everything we now call gender ideology. The words: Samuel Johnson's Dictionary. 1755, the most influential dictionary for 150 years. Sex, the property by which any animal is male or female. Female, one of the sex which brings young. Woman, the female of the human race. Man, the male of the human race. Gender, a grammatical term. Notice what's not there? No gender identity, no gender role, no spectrum, no assigned at birth. Just biology. Two sexes, defined by reproductive capacity. This was the English language for centuries. 1828, Webster's Dictionary. 73 years later, same definitions. Sex, the distinction between male and female. Gender, still grammar. Then in 1955, everything changes. Then one man decided to rewrite the language. The man, John Money, born 1921 in New Zealand, immigrated to America in 1947. By 1955, He was a professor at Johns Hopkins University, and he had a theory. Money believed that gender, who you are as male or female, wasn't biological. It was learned. He believed you could take a baby, raise it as the opposite sex, and it would simply become that sex. He coined the term gender role in 1955. He didn't invent gender identity, but he popularized it. He's the reason we now talk about gender as something separate from sex. But here's what the textbooks don't tell you. To prove his theory, he needed an experiment. And in 1966, he found one. The experiment. Winnipeg, Canada, 1965. Bruce and Brian Reimer, identical twins, born August 22nd, 1965. At 8 months old, both boys needed circumcisions for a minor medical issue. The doctor used an unconventional method, electrocautery. On Bruce, it went wrong. His penis was destroyed beyond repair. His parents were desperate. What do you do with a boy who has no penis? They saw John Money on television, talking about how gender could be changed, how babies were blank slates. They wrote to him. Money saw his chance. An identical twin, a perfect control group. Raise one as a boy, raise one as a girl. Same genes, same environment. If the one raised as a girl turned out female, he'd prove his theory forever. 1967. At 22 months old, Bruce Reimer had his testicles removed. Surgeons constructed a rudimentary vulva. His name was changed to Brenda. His parents were told to raise him as a girl. And John Money became world famous. The abuse. Money required the twins to visit Johns Hopkins every year for follow-up. What happened in those visits, the world wouldn't learn for decades. According to David Reimer, as he later called himself and his twin brother Brian, when they were 6 years old, Money showed them pornography. He made them undress and inspect each other's genitals. He forced them to simulate sexual intercourse. David on all fours, Brian behind him, thrusting. David on his back, Brian on top. Money called this sexual rehearsal play. He said it was necessary for healthy gender development. He photographed the children during these exercises. When they resisted, he became angry, verbally abusive. This went on for 10 years, until the twins were teenagers. Until David, still called Brenda, threatened to kill himself if his parents ever made him see John Money again. The lies. The published record. While Money was abusing the Reimer twins in private, he was publishing papers claiming the experiment was a success. He wrote that Brenda behaved like a normal girl, that she played with dolls, preferred dresses, acted feminine, that she showed no signs of male behavior. It was all lies. In reality, Brenda never accepted being female. He ripped off dresses. He preferred trucks and guns. He stood up to urinate. Teachers and classmates never accepted him as a girl. He was bullied relentlessly, called gorilla, caveman. By age 13, he was suicidal. But Money kept publishing, kept claiming success, kept using David Reimer as proof that gender was learned. And the world believed him. The influence. Money's fake data didn't just fool academics. It changed medicine. Based on Money's success, doctors around the world began performing sex reassignment surgery on infants. Children born with ambiguous genitalia, intersex children, were surgically altered. Parents were told to raise them as one sex or the other. Pick one. Raise them that way. They'll be fine. Thousands of children, irreversible surgeries, all based on Money's lie. His ideas influenced feminism. If gender is learned, then there's no biological basis for sex differences. Kate Millett cited Money's work in Sexual Politics, a foundational feminist text. Time magazine, the New York Times, academic journals all praised Money's proof that gender was a social construct. And the language itself changed. Gender role, gender identity, gender expression. All of these concepts, the entire framework, traces back to John Money. The truth. For 30 years, Money's lie held. Then a biologist named Milton Diamond, who had challenged money since 1965, found David Reimer. Diamond published The Truth. David had rejected his female identity the moment he learned the truth about his biology at age 14. He had transitioned back to male. He had undergone testosterone treatment. He had surgery to reconstruct a penis. He was living as a man, married to a woman. The experiment hadn't just failed. It had proved the opposite of what money claimed. David went public in 1997, Rolling Stone. Then a book, As Nature Made Him. He wanted to prevent what happened to him from happening to others. On the 4th of May, 2004, David Reimer died by suicide. He was 38. His twin brother Brian had died 2 years earlier, an intentional drug overdose. Both of Money's subjects, dead. John Money never apologized, never publicly acknowledged the failure. He died in 2006. Colleagues said he was mortified by the case, but he never said a word. The legacy. Here's what most people don't know. The man who separated gender from sex, the man whose theories justified sex reassignment, the man whose language we now use in law, medicine, and education, was a child abuser who falsified his research. Both of his subjects killed themselves. His experiment proved him wrong, and yet his ideas didn't die with him. They're in our laws, in our schools, in our language. When politicians say gender identity, when schools teach that sex is assigned at birth, when athletes are allowed to compete against the opposite sex because of gender, they're using John Money's framework, built on abuse, built on lies, built on junk science, the laws. Let's revisit the laws. Title IX, passed in 1972, 37 words. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Notice what's there? Sex. Notice what's not there? Woman, female, gender, gender identity. Here's the problem nobody talks about. Read the plain text of Title IX. If you exclude someone on the basis of sex, that's illegal. So what is women's sports? Excluding males on the basis of sex? By the plain text of Title IX, women's sports are illegal discrimination. Women's sports exist despite Title IX, not because of it. They exist because of regulations written by unelected bureaucrats. Regulations that can be changed by any administration without a vote. The same Democrats who wrote Title IX to protect women are now using it to put men in women's sports. The same law, the same vague language, different interpretation. The flaw in the law. Let's look at how we got here legally. Title VII of the Civil Rights Act of 1964, the foundation of American anti-discrimination law. Here's what it says. It shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. 5 categories: race, color, religion, sex, national origin. That's it. That's the list. Notice what's not in the statute. Sexual orientation, gender identity, gay, lesbian, transgender. None of those words appear anywhere in the 1964 law. So how did we get to a place where firing someone for being gay is sex discrimination? A 2020 Supreme Court case called Bostock v. Clayton County. The court used what they called but-for logic. Bostock logic. You can't know someone is gay without knowing their sex. Therefore, sex is a factor. Therefore, it's sex discrimination. Think about that for a second. By that logic, everything is sex discrimination. Fire a man for being a father? Can't know he's a father without knowing he's male. Sex discrimination. Fire someone for having a beard? Can't have a beard without being male. Sex discrimination. The but-for makes the word sex meaningless. Here's the deeper problem. The same legal logic that protects gay people under Title VII is the logic now destroying women's sports under Title IX. If sex can mean anything a court decides, then discrimination on the basis of sex can mean anything too, including women's sports are illegal because they exclude males. You can't have it both ways. Either sex means biological sex, male and female, and the law protects women's spaces but doesn't explicitly cover sexual orientation. Or sex means whatever courts redefine it to mean, and women's sports become illegal discrimination. What the law should have said. So what's the answer? Not better definitions. Definitions can be changed. Not longer lists of protected categories. Lists create endless fights about who's in and who's out. The problem isn't the words. The problem is the approach. What if instead of listing categories, the law established a principle? One principle. Universal application. Here's what Title VII could have said. Original, 1964. To discriminate against any individual because of such individual's race, color, religion, sex, or national origin. Autonomy version. To discriminate against any individual with respect to his or her autonomy. Watch what happens when you apply autonomy instead of categories. Fire someone for being black? Illegal. Their race doesn't affect the job. Doesn't violate anyone else's autonomy. Pure discrimination. Fire someone for being gay? Illegal. Their sexuality doesn't affect the job. Doesn't violate anyone else's autonomy. Fire someone for being female? Illegal. Same principle. Fire someone for being Christian? Illegal. Their religion doesn't affect the job. Fire someone for being incompetent? Legal. Performance actually matters. Their autonomy to keep a job they can't do doesn't override the employer's autonomy to run a functional business. Now here's where it gets interesting. Exclude males from female sports? Legal. Why? Because the male's autonomy to compete doesn't override the female's autonomy to compete fairly against their own sex, have athletic spaces free from biological males, keep their scholarships, records, and opportunities. Both sexes have sports. Neither sex's autonomy is violated. The categories exist to protect autonomy, not violate it. Force women to share prison cells with males who identify as female? Illegal. Violates women's autonomy, their safety, dignity, and bodily integrity. Allow a trans-identified male in a men's prison? Legal. Doesn't violate anyone's autonomy. See what happened there? One principle solved. Race discrimination. Sex discrimination. Religious discrimination. Sexual orientation without redefining sex. Disability without needing the ADA. Age without needing the ADEA. Women's sports. Women's prisons. Every case. No lists, no categories. No word games, no courts redefining terms for 50 years. Just one question. Does this action violate someone's autonomy without protecting someone else's? The founders tried to enumerate rights. The problem with enumeration is that anything not listed seems unprotected. That's why we needed amendments. That's why we needed the Civil Rights Act. That's why we needed Title IX, the ADA, the ADEA, law after law after law, trying to cover cases the previous laws missed. Autonomy doesn't enumerate. It establishes a foundation. Your autonomy ends where another's begins. Everything flows from that. No person shall be discriminated against on any basis that does not materially affect legitimate interests or that violates the autonomy of others. One sentence. Replaces Title VII. Replaces Title IX. Replaces the ADA. Replaces the ADA. Replaces the Fair Housing Act. One principle. Every case. No loopholes. No word games. This is what the law should have said from the beginning. And it's not too late to say it now. John Money wanted to prove that gender was a blank slate, that you could make a boy into a girl with surgery and upbringing. He was wrong. David Reimer knew he was male despite everything done to him. His body knew, his mind knew, biology doesn't care about ideology, but money's language survived. His framework survived. His separation of gender from sex survived. And now it's being used to do to thousands of children what it did to David and Brian Reimer. If you use the word gender to mean something different from sex, you're using a term popularized by a child abuser. If you believe gender is learned, not innate, you're believing a theory disproved by the death of its own test subjects. If you support laws based on gender identity, you're building on a foundation of abuse, lies, and junk science. David Reimer wanted his story told so it wouldn't happen to others. It's happening to others. Right now. Today. The only way to stop it is to reject the framework entirely. Not gender identity. Not gender roles. Not John Money's language. Autonomy. Your autonomy ends where another's begins. That's the principle that protects everyone.